As Christina said, my name is Laura Stover, and I am the Director of HR Advisory Services at SEK. I've been with the firm for just over 13 years now, and my role is to provide HR consulting services to our clients throughout the firm. So in all 6 offices, any type of client I can help with HR needs. And this morning, I'm going to be just doing a brief employment law update. We've actually had quite a bit going on in 2024 so far. I'm going to touch base on the Department of Labor's final rule on the minimum salary threshold. I think everybody's heard this and been aware of it. It's a pretty hot topic. I'm also going to discuss the Pregnant Workers Fairness Act final regulations. We'll take a look at the EEOC's new guidance on workplace harassment, and then finish up with the Department of Labor's final rule on how to classify an employee versus an independent contractor. All right, so let's get started with the Fair Labor Standards Act updates to the minimum salary threshold. So under FLSA, there are what's called the white collar or EAP exemptions, and that's executive, administrative, and professional. And in order to place an employee in one of those exemptions and make them salaried, they have to make a certain minimum salary. And this used to be $684 per week, $35,568 annually. Was just a couple weeks ago, it raised to $844 or $43,888 annually, excuse me. That's as of July 1st. And coming January 1, 2025, it's moving to $1,128 or $58,656 annually. Now, of course, that is a really big jump. It's about 65%. So this is having a pretty big impact on employers. And I wanted to mention, you'll notice throughout the presentation that there's a lot of links in the documents so that when you receive the document via email, you'll be able to click through some links and get even additional information if you need it. I wanted to review how you actually make an employee salaried exempt, because I feel like there's a lot of misunderstanding about that within employers. There's actually a 3-part test to this. And the first part is the minimum salary threshold that we've just discussed. In order to place someone in the executive, professional, or administrative exemption, they have to be making at least $43,888 annually or $844 per week. And that's the case whether they're full-time or part-time. That salary threshold has to be met. If they are not at that level, they cannot be classified as exempt. And it's important to note that under the professional exemption, the salary requirement actually doesn't apply to teachers, doctors, and lawyers. Employers can continue to still use non-discretionary bonuses, incentives, and commissions to make up 10% of that $844 per week or $43,888 annually. As a reminder, a non-discretionary bonus is one that is objective and has set criteria, and it's expected to be paid, once that criteria is met. It's also interesting to note that the salary threshold is going to increase every 3 years, starting July 1, 2027. So this first part of this test is a moving target. It's always going to be changing and something that you need to pay attention to. If the person is meeting the minimum salary threshold, then you look to see if they're paid on a salary basis. There's really limited times when you can take a deduction from an exempt person's salary. They should be getting the same amount every pay period, regardless of quality or quantity of work. And when you take deductions that aren't permitted, that jeopardizes their exemption and could make them non-exempt and eligible for overtime. So the third part of the test is the job duties test. And I feel like this is kind of the part that's glossed over a lot by employers. In order to place someone in executive, professional, or administrative exemption, their job duties and responsibilities have to meet the requirements of that exemption. So for example, with the executive exemption, if you want to place an employee in that exemption, they have to have their primary duty being managing like a department or an enterprise. They have to direct the work of at least 2 full-time employees. And they also have to have hiring and firing authority. So if they meet the minimum threshold, they're paid on a salary basis, and they meet those job duty requirements, then you can place them in the exemption. And again, the professional and administrative have other job duties that you need to take a look at. And the biggest mistakes I see are people simply just going by job title or because they want to make someone salaried because it's easier or the employee has requested it. So you want to make sure that you are following this 3-part test before you place someone in one of those exemptions. I did want to mention the highly compensated employee. This doesn't apply a whole lot, probably not a lot in the public just because of the nature of the salaries. But this is actually part of the white collar exemptions, executive, professional, and administrative. And what this says is if you have an employee whose primary duty is performing office or non-manual work, and they regularly and customarily perform at least one of the job duties of those exemptions that I mentioned, and they're making this higher salary, you can go ahead and make them exempt. It's just a little bit easier of a way to make someone exempt who's at a high salary. I find that most people at the high salaries are meeting all the job duties requirements usually anyway. But I did want to mention this because you can see those numbers increased significantly as well. Next step for employers, definitely look at July 1, make sure you are reviewing for the 42,888 number. We don't know if the January 1 increase will go through. There's a very good chance it will. So you want to make sure that you are preparing. If you have an employee who's classified as exempt and they are meeting the minimum salary threshold, go ahead and take the time to make sure they're being paid on a salary basis and that their job duties are meeting the exemption to make sure that they're properly classified. Because again, it's not just about salary. If you have employees who are not meeting the salary threshold, obviously you're going to have some decisions to make. I think a lot of employers are concerned about that January 1 number. If they're not meeting the salary threshold, you have to look at that and say, does it make sense to give them an increase, or is it just, too large and doesn't make sense at all? And in that case, you're going to have to reclassify the employee to non-exempt if they just cannot meet that minimum salary threshold. And that's a pretty significant change. You have to make sure that you are tracking and recording all their hours because they're paid by hours worked. They have to be paid for any overtime for hours worked over 40 in a work week. And the employer is required to retain those records. And you're going to have to figure out what hourly rate you're going to pay. And that, may not be dividing by 20, 80 hours. If that person has worked a lot of overtime, you may need to back into it. And another consideration is benefits. I know some employers will have different benefits based on non-exempt and exempt for maybe paid time off or premium payments. So you want to make sure you're considering everything when that change happens. And you may even want to decide to hire some part-time staff or something to supplement your workforce if you have a lot of people who are working overtime and now have to be non-exempt and you don't want to incur that overtime cost. And of course, you want to consider the impact on employee morale. Some people look as going from exempt to non-exempt as a demotion. So you want to make sure you share that you value that employee. This is simply an adjustment that needs to be made per wage and hour law. And on the positive side, they can now be eligible for overtime and possibly additional compensation. And of course, you want to develop a communication plan, communicate what any changes are verbally as well as in writing, especially when someone is going non-exempt. Okay, so changing gears a little bit to talk about the Pregnant Workers Fairness Act. This actually became effective last year, but the guidance and the regulations just came out in June. And this act covers public and private employers that have 15 or more employees. And what it says is that covered employers have to provide reasonable accommodations to a qualified employee's known limitation that's related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, unless you can prove undue hardship. And undue hardship means really significant difficulty or expense. So that's actually pretty hard to prove. Most likely you're not going to be able to prove undue hardship. And most people, I realize, want to make accommodations. But it's interesting that this act uses the word limitation. That's a higher standard that employers are going to need to meet. Under the Americans with Disabilities Act, the employee actually has to have what's called a qualified disability. Under this act, it's simply a limitation, which means there's going to be more accommodations. In order to be qualified, typically an employee has to be able to perform the essential functions of the job. And that's how, again, things are under the Americans with Disabilities Act. If you have a disability, you have to be able to perform the essential functions. Under the Workers Fairness Act, the employee can still be qualified even if they cannot perform one or more of the essential functions of the position. And that's because if the inability is temporary or they can perform it in the near future or there's an accommodation that can be made, you're going to have to go ahead and accommodate them. Again, pregnancy is temporary, so they don't see, you definitely have to provide an accommodation. There's no way you're going to get out of doing that because it's for a limited time, unlike typically someone with a qualified disability under ADA. I just wanted to show a list of some possible accommodations. I know a lot of these are pretty obvious and most employers can make these. Things like having additional breaks, maybe needing more water or to possibly eat some food during the day outside of lunch, maybe adjustments to workstations, needing to wear a different uniform, maybe changing jobs or having light duty, being able to have the time to go to medical appointments, all the typical things you would think of when someone's pregnant. I do want to mention that you have to be careful with asking for medical documentation under this act. You should not ask for medical documentation when the pregnancy and accommodation are obvious, if it's asking for pumping at work, if the limitation or accommodation are already known, if it's a predictable assessment, which means things like eating, drinking, standing, or if normally you don't ask for medical documentation. Let's say maybe you have a clerk who's 3 months pregnant and maybe they need some additional bathroom breaks and they come and ask you for that. In that situation, that's obvious. It's a predictable assessment. If you want to go ahead and make that accommodation, do not make them go, to the doctor and prove that they're pregnant again because it's obvious. So you want to be careful with that. Next steps, you want to make sure you have a reasonable accommodation policy in your handbook. And there's a lot of different ways you have to make accommodations. It may be for pregnancy, it may be for disability, it may be for religious reasons. And you can put that all in one policy, or you at least need to have those things mentioned in several policies. And, if you're looking for a policy, that's something we can help you with. Of course, you want to train managers to recognize and promptly respond to any requests from pregnant employees, make sure there's no retaliation. And again, there's a link here to the key provisions of this act. If you want to get into more detail, I suggest you just kind of take some time to review that information. The EEOC has updated their guidance on harassment prevention, and this is significant because they haven't updated it since 1999. And I know whenever we say anything in the 90s, that seems like a super long time ago, and it kind of is. They've now updated the guidance to reflect, the modern workplace. So there's a lot of talk in the regulations about things like social media and virtual work and misgendering, just the type of things that we are dealing with today. I don't have time to review all the key provisions. Again, there's a link. On the next screen, though, I wanted to share that the EEOC strongly encourages employers to have a clear and easy to understand anti-harassment policy. It's really important that your complaint procedure is clear and easy to follow, and you should have more than one avenue to complain to. So, for example, a person should be able to raise a complaint to their immediate supervisor or manager. They should be able to go to like the borough manager, the town manager, or even to the board. You just never know where the harassment may be taking place. So you want to make sure that there are definitely different people they can, make a complaint to and ensure that they actually receive a response. You also want to make sure that there's a no retaliation statement in your policy. Most charges that the EEOC receive are retaliation charges, and that's because people get upset when they're accused of something. So you want to make sure you're following those laws, and also make sure you're putting in there that you're going to do a prompt and an impartial investigation. Of course, you want to make sure that you are training all your managers, especially management and employees, on harassment and putting your policy out there. When you take the time to have a good policy, to communicate the policy, and to train your employees, you're actually going to have what's called an affirmative defense. If you receive a hostile environment claim on harassment, you can show that you've communicated the policy, you've done what's needed to be done, but the person failed to follow your procedures. Now, if you have something happen that's quid pro quo, where a manager, there's some type of loss due to a manager harassing an employee, then, you're going to be liable in that situation. But I encourage you to take the time when you have and meetings just to occasionally revisit your policy, be talking to your employees, and make sure that they're comfortable in the work environment and that you don't have inappropriate behavior going on. And again, there's a link to policy tips on here. I definitely recommend that you take a look at that.
Hey, Laura, we have a question.
Okay.
Is there an exemption for the overtime policy for religious organizations / churches?
That's kind of a long question. First of all, the church, there is something called a ministerial exemption for a pastor, but we would need to talk specifically about the positions within a church. They can be covered under all of this. So there's not a blanket exemption for churches, but there is some exemptions at the pastor level. Any other questions?
No, that was the only one.
Okay, and I'd be happy to talk about that further with whoever had that question. And finally, the department's final rule on employee or independent contractors. I really encourage you to take a look at this if you currently have an independent contractor. There's a six factor economic reality test that we have to look at now. And none of these factors carry any more weight than the other one. So it's really a case-by-case basis. So the first factor is opportunity for profit or loss depending on managerial skill. So if the person is really doing their own marketing, their own advertising, they're accepting declining jobs, setting pay, that really leans towards independent contractor status. With number two, investment by the worker and the potential employer. The more investment by the person, that's going to lean towards independent contractor status, where if there's not, any significant investment, that's more likely an employee. Number three, the degree and permanence of the work relationship. If the relationship is indefinite, it's continuous, it's exclusive to the employer, that's really going to lean more towards an employee versus an independent contractor status. Number four, nature and degree of control. The more control the employer has, if they're setting schedules, if they're taking disciplinary action, that's definitely going to be more of an employee relationship. Number five, extent to which the work performed is an integral part of the potential employer's business. That the more critical it is to the business, the more essential the work that employee is doing, that's going to lean towards more of an employee status. And lastly, skill and initiative. If someone's bringing a more specialized skill, that definitely leans towards the independent contractor status. And there's a lot of gray area with this. Again, you have to look at all six factors. None carry more weight than the other. But definitely, if you have an independent contractor, take a look at this. Even if you have a written document that's signed that says, hey, you're an independent contractor, that's not going to keep you from possibly getting a claim if you have somebody misclassified as an employee. And again, there's a link. Take a look at the small entity compliance guide. There's some additional information and a little more detail on each of these six factors. A poll just popped up, so make sure you go ahead and click on that. And final screen here, any questions? I know we had one. Does anybody else have any thoughts or questions they'd like to ask?